Hello, sorry for my voice, and welcome to the Commonwealth Club World Affairs program for the night. I am Catherine Lehman. I am Executive Director of the Edley Center on Law and Democracy at University of California, Berkeley School of Law, and I am delighted to be in conversation tonight with Cecilia Wong. She is the National Legal Director for the ACLU, and in that capacity, she leads the ACLU's Supreme Court litigation docket. Cecilia has been with the ACLU for now more than 2 decades, which is very lucky for the ACLU.
I'm very old.
That's not at all the take home. It is just the ACLU's luck on that. Most immediately before becoming the National Legal Director, Cecilia was the director of the ACLU's Democracy Project, and before that, she directed the Immigrant Rights Project at the ACLU. She started as a trial attorney in the Federal Public Defender's Office in the Southern District of New York, and she went to law school at Yale Law School with me, and she was an undergraduate at University of California, Berkeley, which was a nice choice also.
A very good choice.
Yes. And she clerked for the Honorable William A. Norris.
As did Catherine.
As did I. And so we're kind of trying to be the same person immediately after law school. And then I did not do this, but Cecilia went on to clerk for Justices Blackmun and Justice Stephen Breyer at the United States Supreme Court. So, speaking of the United States Supreme Court, let's just jump right in.
Okay, let's do it.
Yeah. The latest statistic that I've seen is that the Trump administration has had an 84% success rate in the United States Supreme Court, which is an astonishing figure. I have also seen a figure that the ACLU has an 84% success rate in the litigation that it brings when it seeks relief. So I want you to talk to us about how the ACLU chooses its cases, which cases to bring in the United States Supreme Court, and how to bring them, and also why you are confident that litigating in the United States Supreme Court about civil rights and civil liberties now is a worthwhile endeavor.
So thank you so much, Catherine, for that warm welcome, and thank you to all of you at the Commonwealth Club tonight and listening in. So, there's no doubt, as you know, Catherine, that the Supreme Court has often been hostile to individual civil rights and civil liberties. And this is not only true of the current court, but it's been true since you and I graduated from law school in the mid-90s. And at that point, it was a 5-4 conservative majority on the court, often hostile to individual civil rights and civil liberties, and now it's a 6-3 hostile majority. So to answer your question, how do we decide which cases to bring up to the Supreme Court? I have to back up a little bit and talk about how we decide on the cases we're bringing in the lower federal courts.
Of which there are more than 110 right now, just to say.
That's right.
Kind of busy.
As of this afternoon, we have 111 actions filed against the Trump administration in his second term. And we're almost at 200 total legal actions, which would also include filing amicus briefs in support of others challenging the Trump administration, and filing Freedom of Information Act requests and administrative complaints that may be a prelude to federal court lawsuits. So we started preparing for Trump's second term way back in January of 2024. Personally, I thought Donald Trump was going to win all 3 times he ran for president. Wow. I was right 66% of the time. So, luckily, for better or for worse, Trump had this so-called Project 2025, which was a blueprint that conservatives had put together, led by the Heritage Foundation, that outlined various kinds of policy actions that they wanted President Trump to take should he be elected to a second term. And we used that blueprint as a way to basically start road mapping our defense of civil rights and civil liberties. And so when Trump was elected in November, and when he took office on January 20th, we were ready to go. Within 2 hours of his issuance of his executive order that purports to bar birthright citizenship, in violation of the 14th Amendment of the Constitution. Flagrant violation, yes. We had filed our first challenge. And as a result of that litigation and a second follow-up case that we can talk about, no child born in the United States has been deprived of their birthright citizenship thanks to the litigation efforts. So to get back to the Supreme Court, we basically, the Trump administration has taken so many actions that are in violation of the Constitution or statutes enacted by Congress that violate people's rights and liberties. And so, we tried to bring lawsuits wherever those unlawful executive actions intersect with ACLU priorities, which again are all about individual rights and liberties. We have generally left issues like the mass layoffs of federal employees to others. And so, for example, in the lower court actions, we have, again, gotten relief, as you said, over 80% of the time where we've tried to get some kind of preliminary relief. And, in addition to birthright citizenship, we have stopped the deportation of Venezuelans under Trump's invocation of the Alien Enemies Act of 1798. We have challenged the arrests and detentions of immigrants who've showed up for immigration court in order to try to defend against a deportation charge. We have a case that may be close to your heart as a former Assistant Secretary for Education, successfully enjoined the Department of Education's so-called Dear Colleague letter, which purports to defund educational institutions, K through 12 and to higher education, that engage in efforts that Trump would deem to be diversity, equity, and inclusion, or DEI efforts. There have been a number of those cases. We have blocked Trump administration actions to defund the National Endowment of the Arts grants based on so-called promotion of gender ideology. We have blocked an effort by the federal government to take down scientific research papers from a government-run website called PSNet, based on those research papers' use of a list of forbidden terms by the Trump administration, which includes not only DEI, diversity, gender, but also things like COVID, vaccine hesitancy, right? And so we've gotten an order against that. We have gotten orders from courts blocking various anti-transgender initiatives of the Trump administration. We have successfully blocked the detention by ICE of immigrants based on their First Amendment protected rights. So, for example, famously, one of our clients, Rumeysa Ozturk, a graduate student at Tufts University in Boston, wrote an op-ed in the Tufts student newspaper that spoke out in favor of the rights of Palestinians in Gaza. And she was detained on her way to an iftar dinner near the Tufts campus and was detained for 7 weeks in Louisiana. Thousands of miles away from home, and we successfully got her out of detention and are now helping her with her immigration case. Thank you. I could go on and on and on. So we have filed 110 lawsuits. We have had a success rate of over 80% where we've tried to get some kind of injunction from a court. And then we come to the Supreme Court. So let me say first, it's rare that the ACLU is actually the ones trying to get the Supreme Court to take a case of ours.
Right now.
Right now.
Yes.
Our cases, sometimes we're the ones going to the Supreme Court. For example, last term, we represented the NRA in a case under the First Amendment that we took to the Supreme Court, or we were invited to join once it reached the Supreme Court. But by and large, among our cases against the Trump administration, we've won the cases in the lower federal courts, and it's the Trump administration that is taking the case up to the Supreme Court. And so, that's a long way of answering your question, but, we try to, we formulate our cases from step one in the federal district courts in a way that is calculated to prevail all the way up through the courts of appeals up to the Supreme Court. And we can talk about what our track record has been in the Supreme Court.
It's been pretty good. So we'll just pause for that. But staying with the Supreme Court, this is going to be another blockbuster term: voting rights, possibly birthright citizenship, which you've mentioned. Sex discrimination, the actual disadministration of law and executive authority. All of those are on the docket this term in the Supreme Court, and they're all in cases that you're actively litigating. So do you have prognostications, tea leaves that you can share with us, predictions for this court, and can you talk to us about what's at stake in this term and how it compares to other Supreme Court terms?
Yeah, so this term, October term 2025, is shaping up to be probably our busiest term in ACLU history. We already have 3 cases that are before the court. They are a case called Calais versus Louisiana and Calais versus Robinson, where a group of self-described non-African American Louisiana voters are challenging the congressional redistricting map that the Louisiana legislature drew after we won a Voting Rights Act challenge to their initial 2022 map, which we prevailed in district court, showing that they illegally diluted the voting power of Black Louisiana voters. That was a case that is being carried over from last term. We are on the case with the Legal Defense Fund, and after the case was argued last term, and the issue was, did the Louisiana legislature, according to these non-African American voters, did the Louisiana legislature violate the Equal Protection Clause of the U.S. Constitution by redrawing a map that complied with the Voting Rights Act? So this is, in a way, one of these cases where a group of white plaintiffs are alleging some kind of so-called reverse discrimination. And so we argued the case last term in the Supreme Court. The court, at the end of the term, in the end of June or the beginning of July, didn't decide Calais, but instead set the case for re-argument and asked a somewhat ominous question, which was, did the Louisiana legislature's drawing of a second majority Black district violate equal protection? That case was just re-argued 2 weeks ago, and we're waiting for the outcome there. The second and third cases that we have at the Supreme Court already on their merits docket this term are cases that are where we challenged 2 state laws in Idaho and in West Virginia that categorically barred trans girls and women from playing on girls and women's sports teams in K through 12 schools and in colleges. In these 2 cases, we represent a young woman, Lindsay Hecox. In the Idaho case, she is a transgender woman who tried out unsuccessfully for the University of Idaho's actually, it was Idaho State, I think, her college track and field team. Didn't make it, was not fast enough, and is just playing club soccer and club track and field, non-competitive.
Which is more than I could do, but still. Yeah,
right,
yes.
But still, and so the Idaho law would bar people like Lindsay from participating in sports the same way that everybody else does, and applies to not only competitive, NCAA level athletics, but even to, high school students. In our other case, in fact, against the West Virginia law, our client BPJ is a high school student, a trans girl, who was treated for gender dysphoria from a young age and has never gone through endogenous male puberty. And yet, the state of West Virginia, in passing this law, automatically sought to make her ineligible to play on her high school soccer team, as she had been doing with her classmates, for since she started high school. So those are the 3 cases we already have on the Supreme Court's calendar this term. And we have 3 other cases that are kind of in the pipeline and could be potentially taken up by the court 2 of them are also redistricting cases. In Alabama's congressional redistricting case, if this feels like deja vu to you, it's because 3 terms ago, a little over 2 years ago, we won our challenge in the Supreme Court to Alabama's post-2020 congressional map, which we successfully challenged under the Voting Rights Act as, again, illegally diluting Black voters' voting power, and got, again, a second Black Opportunity District. And Alabama, when the case was sent back down, instead of saying, okay, you won in the Supreme Court, we'll go ahead and, we'll comply with the law, they decided to draw another map that deprived Black voters of an equal opportunity. And this time around, they were so blatant about it that the federal district court found that they intentionally discriminated against Black voters in drawing the congressional map. So, that case potentially is going to be back at the Supreme Court. We won below again, and Alabama has now filed a direct appeal from the 3-judge district court there. Similarly, in Mississippi, we won a challenge to Mississippi's state legislative map, and we were successful in getting 5 additional Black Opportunity Districts in the state legislature, both the House and Senate, and we won below, and the state of Mississippi is trying to get the Supreme Court to take the case. And finally, the most recent development is that in our second case challenging the president's executive order seeking to bar birthright citizenship, the government is asking the court to take our case, as well as a case brought by the state of Washington. And so that's probably a likely case that'll be up at the court this term.
And that's just what we know about now, right? So busy times.
Yes.
Busy times. You've talked about these cases with such heart, and I've known you a long time. I wasn't necessarily going to tell you all how long we've known each other, but thank you that you already did. So, but I've known you, and I know that these issues are not just abstractions for you. They're not just legal issues, and there's a right answer or a wrong answer. You come to these issues with your whole heart. And just to share with our audience, Cecilia has sometimes sent me photos of her clients when they gain naturalization, and their clients and their families, so we can both celebrate the success and where they are. And so I'm hoping you can talk to us about how you manage litigating with heart as well as mind, and the brilliance that you bring to it, or the justice that you bring.
What a great question. I think it's especially important, and especially hard to do this right now.
Yeah.
Because it feels like we have so many opponents who are bringing everything they've got against our clients,
Yes.
who are simply trying to live their lives, and have the same equal rights, dignity, and liberties that everybody else has, whether they are a disfavored and politically vulnerable minority like trans youth or immigrants, or, these days, this administration is not limiting itself, as it did in Trump's first term, to going after these disfavored minority groups. They're really launching a full-out attack on mainstream democratic, small d democratic institutions, law firms, lawyers, judges,
Right.
who have ruled against
Right.
the president and his administration, journalists, universities, right? And so it's an important question that you're asking. I think the first thing to keep in mind is that we all do this together. I don't know how many of you attended the No Kings protest. Yeah. And, it just this past couple weekends ago, or in June. But it's so important that we tap into the groundswell of people across the partisan spectrum. The ACLU obviously is nonpartisan organization. We sue government officials, federal, state, and local, of both parties. We've sued every president when they have violated people's rights. But, we really need to seize an important moment and seize a silver lining that comes with Trump's all-out kind of blunderbuss approach to attacking democracy as well as civil rights and civil liberties. And that is that there's something for everyone not to like these days about what this administration is doing. And we are increasingly, I'll give you an example. President Trump has issued executive orders that target certain law firms for representing certain clients or causes that the president doesn't like. Blatantly violates the First Amendment. And the first order issued against Covington and Burling, and it was a narrow order compared to the ones that followed. The second order he issued was against Perkins Coie. And it blatantly said, we are targeting the whole law firm because a former partner in the firm, Mark Elias, had represented Democrats that Trump opposes, and purported to bar every lawyer in the firm from entering public buildings, federal buildings. Just really extreme stuff. So I called up a friend who is a partner at Perkins Coie, and I said, what do you need? How can we help? And he said, can you file an amicus brief and line up a right-left coalition of nonprofit civil rights organizations to stand up for us? And I have to tell you, things changed over the course of that litigation, but when I had that conversation with my friend, all the other law firms, all the other big law firms wouldn't touch this with a 10-foot pole. And you probably remember there was a lot of reporting about this at the time, that when Trump issued these orders against Perkins Coie, Jenner and Block, Wilmer Hale, and Sussman Godfrey, other law firms wouldn't initially speak out. And there was a law firm, Paul Weiss, that entered into a settlement agreement with the president, and the head of the firm, managing partner, who had negotiated that after taking a lot of flack for doing that, said, you have to understand that in those early days, when Paul Weiss was one of the first law firms that was targeted, these other law firms were trying to poach our clients. Other law firms wouldn't come to our aid. So I lined up with my colleagues at the ACLU truly a right-left cross-ideological amicus brief with organizations who identify as conservative, Society for the Rule of Law Initiative, the Cato Institute, Rutherford Institute, and many others who joined forces with the ACLU, with the Knight Institute for the First Amendment, with FIRE and others, to say it is time for a broad spectrum of the American public and the legal profession in particular to stand up to this president in defense of the ability of the legal profession and lawyers to represent causes and clients zealously as they see fit.
And as our Constitution expects. Right?
And as
that's the actual
exactly
process that we anticipate.
Exactly. Right? So that's number one. There's a silver lining to this, the extremeness of this administration, which is that a large swath of the American public and of advocates and people who are being targeted by the Trump administration are joining forces, and that group is growing and growing by the day. And so that's number one. The second thing that really gives me hope is, I'm a second-generation American. I grew up in Fremont, right here in the Bay Area, and my parents were immigrants, and they immigrated in the late 60s, and they were able to do that because of the Immigration Act of 1965, which lifted racist quotas against immigration from Asia, Africa, and Latin America, and lifted, quotas on Asian immigration that had been in place for since the founding of our country.
Right.
And that Immigration Act of 1965 happened because of the Black-led civil rights movement. And it happened...
That's right.
It happened after the Voting Rights Act of 1965 was passed, and happened after the passage of the Civil Rights Act of 1964. And both of the 1965 statutes, major reform legislation, Voting Rights Act and the Immigration Act, happened because of John Lewis and other Black civil rights activists who were beaten bloody in front of the cameras for all the world to see on the Edmund Pettus Bridge in Selma, Alabama. Bloody Sunday happens in March 8th, I think, 1965. Right. And by the end of the year, Congress had enacted the Voting Rights Act and the Immigration Act, and President Johnson had signed both of them. So what we know, there's an intersection here between my personal life, the fact that I'm a U.S. citizen, an American civil rights lawyer, is directly linked to not just the civil rights movement of the 60s, but everything that came before it.
Right.
So even now, as the Supreme Court is considering whether to dismantle Section 2 of the Voting Rights Act in major ways, I know that it took a civil war to get the Reconstruction Amendments, including the 15th Amendment, guaranteeing the equal right to vote. And then it took 100 years of Jim Crow and retrogression, deliberate retrogression in southern states, trying to foreclose Black Americans from exercising the rights conferred by those Reconstruction Amendments. It took 100 years of Jim Crow, leading up to the civil rights movement, overthrowing Jim Crow with this Voting Rights Act of 1965, which also led to my becoming a U.S. citizen. And then it took another 50 years for our opponents, for those who want to move backwards on voting rights, to win Shelby County versus Holder, which was the Supreme Court case in 2013 that effectively struck down federal preclearance, another major piece of the Voting Rights Act that protects minority voters. And so, we then immediately came back fighting from Shelby County versus Holder. Shelby County versus Holder, was decided in the spring, and within a couple months, the state of North Carolina, the legislature of North Carolina, deliberately went and researched. We found this out in the litigation and, produced the smoking gun evidence.
Right, it's documented. Right.
It's documented.
Yes.
They deliberately went out to look at voting patterns. They said they were incensed that Barack Obama was elected president, the first Black president. So they went and found out when Black voters show up, how do Black voters vote, and when do they vote, and they tried to foreclose those early voting days. They deliberately tried to disenfranchise Black voters with this voter suppression law. We immediately challenge it and win, right, after a long period of time fighting that case. And
the judge saying it was done with surgical precision.
That's right.
Yes.
The court said that the North Carolina legislature, with surgical precision, as you said, Catherine, was trying to disenfranchise Black voters. And it was done because they did not like the outcome of the 2008 and 2012 elections. And so, we're in this process now. If you put yourself on a timeline as an individual human being, as an advocate, as an institution, as the ACLU, put yourself on that timeline and you realize that our ancestors in this work did much harder things.
Right.
They faced much greater personal risk, and many of them did not live to see the fruits of their labors. And so we have an enormous amount of privilege here to do this work under the conditions that we do, even though they are very hard. And, I always think about, there was this book called Devil in the Grove that is about an early case Thurgood Marshall did as an LDF lawyer defending some black men who were accused of rape in Florida, northern Florida. And it talks about how, it's totally trumped up charges, racist prosecution, small town in the deep South in northern Florida. And the book describes in vivid detail how Thurgood Marshall and his co-counsel, having to try a case in the segregated South as black lawyers, would leave court every day and literally have to outrun the Ku Klux Klan.
Right.
They were chasing them, trying to kill them.
Right.
If they could do that and prevail and make the wins that make our work possible, that make it possible for me to be who I am, we can do this.
Yes. 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 I want to pick up on that and then turn to another question about you. But you started that beautiful history lesson by pointing out the most recent history, which is when the president started issuing executive orders against law firms were principally capitulating. And when you and your colleagues asked, what do you need? The answer was, well, they've been trying to poach our clients. That's pretty different from trying to kill us because we're litigating, right? I mean, the stakes are high. I accept that, but they're much less high than kinds of stakes that we've seen in times past. And we saw principal institutions of protecting our democracy, the lawyers who are white shoe law firms saying, we'll accept patently unlawful action because we're not going to challenge it. But the ACLU, as you pointed out, was within 2 hours of unlawful action in court trying to litigate it. So I just want to say thank you for that.
Thank you, Catherine. Thank you, Catherine.
Yeah. So staying with the personal, in addition to the historical in the moment we are, I said you're newly the National Legal Director for the ACLU. You're also the first woman of color ever to hold that position. You're the first woman ever to hold that position. That's right. That's right. And yay for the love. Also, you took that role in September. So you were eyes wide open about how hard it would be. You were eyes wide open about this challenge, and you ran at it. Talk about what it's like to be those firsts now.
Yeah. I already said, there were not only our ancestors in this movement work, but my literal ancestors.
Yes.
My parents immigrated here. I feel my cousin's actually in the audience. I think she was the one who's whooping and hollering.
Exactly.
Whooping and hollering. Thanks.
She was one among
thanks,
many.
Eugenie.
Yes.
So, our parents immigrated to this country for graduate school, and I just remember hearing their stories actually quite late in my life. My parents did not volunteer their stories of hardship, but I sought them out as an adult, as an advocate for civil rights, and particularly as an immigrants' rights lawyer. I just think we really were made for times like this. And I tell this to my colleagues at the ACLU, the National Legal Department. We've got about 225 staff, lawyers, paralegals, mostly. And, I think we really have a sense of steely resolve.
Yes.
We were ready for this. We had our roadmap we've been working on for a year. And we know that, no one does this work alone. Our clients are incredibly brave. It takes much more courage to be a client than to be the lawyer in many of these cases. And so, we just stand together.
Right.
We stand together.
So speaking of standing together, we've talked a lot about the ACLU's litigation and your work in the ACLU holding down our rights in the Supreme Court. Will you tell us what you hope that those of us who are not the National Legal Director of the ACLU will do to protect our democracy now?
So, I want to flip this question back on you too, Catherine, but, we've already talked about the importance of protest. We've talked about the importance of, having hard conversations. I think the fact that in many ways our democracy is fundamentally flawed, as we were talking about in the green room, because because of gerrymandering, because of, structural flaws in our democracy. And one of those structural flaws is the fragmentation of the media landscape. We all have an obligation, I think, to persuade those around us who are closest to us to, change their minds if they are on the other side of some of these issues that we're talking about in terms of individual rights and liberties and the future of American multiracial democracy. A second thing I think that we all need to do is to obviously vote and get friends, family members who don't live in San Francisco or California.
And do. Everybody votes.
Everybody
all the time,
votes.
Every election. Yes.
But, for friends who live in swing districts, to be sure to vote. And, I think one of my colleagues, Ben Weisner, who you know too, recently said, someone asked him when he was speaking on a panel like this, they said, are we in a constitutional crisis? And he said, well, that depends. Do you think we're in a constitutional crisis? If you think we're in a constitutional crisis, then we are. If you think we're not, then we won't be. And so I think, Ben's answer is one that I think really resonates because, I just keep coming back to this. On election night, when it became clear that Donald Trump had won, I started reading James Baldwin, and particularly his letter to his nephew, right? And, I think the final thing I'll say about what we can do, you got to do the hard work. You got to protest. You got to vote. You got to get other people to vote. You got to give money to organizations that are meaningful to you, and you got to support state and local government officials who are doing the right thing. You got to hold their feet to the fire too, to make sure that we are pulling every lever we can to save our country from sliding into a place we don't want it to be. And in the course of doing all that, you have to remember to be joyful and to celebrate what an amazing aspirational document the U.S. Constitution is, right?
Is and has been, yes.
Is and has been and will be and will make it better.
Yes.
Which brings me to a question I have for you, which is, Catherine started out by saying, we started out with a similar path, going to Yale Law School, same time, clerking for the same judge, Bill Norris, on the Ninth Circuit. Catherine was an ACLU lawyer, too, and then worked at Public Counsel and the National Center for Youth Law. So you started out in nonprofits doing civil rights advocacy, and then you ascended to these really critical positions in both federal and state government as Assistant Secretary for Education in both Obama and Biden administrations, the chair of the U.S. Commission on Civil Rights, and serving as Governor Newsom's top lawyer as his Secretary for Legal Affairs. And so I'm curious to hear what you think the role of those institutions is, and what's the work going to look like when we emerge from our long national nightmare?
Right.
How are we going to put it back together again, right, on the federal level?
Yeah, I appreciate the when rather than the if in that question, and I think we do need to hold on to that hope, right, and that's the expectation. But I think both of us have been doing public service work throughout our legal careers, and I have done it in government in addition to in nonprofits. But I think all of that is lawyers working to uphold our constitutional promises and working to uphold our federal and state statutory guarantees about who we will be, how democracy will function, and what it will mean. And in those many roles, I had the delight of working for President Obama before President Trump became president. And now I've twice watched the Trump administration tear down a lot of the democracy-sustaining principles that we've had over a lot of time. That's quite hard. When I was the governor's lawyer in California, it was the first 2 years of the Newsom administration. So it was a lot of counter to Trump 1 work that we were having to do as a state, and also work to shore up who we would be as a state. And then the pandemic came, and that challenged my lawyering in a way that I certainly hadn't expected. I think none of us had expected. It was once in a 100-year questions that we had for our state and for the nation about how the law would apply, how we could protect in truly life or death kinds of questions. So I guess my experience in those various roles is we're very resilient as a country, and we're very resilient federally. We're very resilient in our states. We've got lots of really talented people who deeply care and who want to do the work. I hope that we're not always in the polarization that we're in now. But I also hope that we are able as a country in individual states and nationally to remember that we have equality as our core principle in what we aspire to be, what we promise to be, and how we hold ourselves out to be. And that it's important for us to live up to that and to constantly aspire to that and to keep working toward it, which I think we can do. We have a history of having done. And it's really nice for me to be watching you and our many states still working to do that. And I think we need to be arm in arm, hand-holding to get that done.
That's right.
Yeah. Back to you.
Okay.
But thanks for the questions for me also. You mentioned having grown up in Fremont, and I noted that you went to college here. You grew up in California. I know that you're still resident here in the state, and I want to talk about how California has shaped your legal outlook and has shaped how it is that you are thinking about the work that ought to protect all of us nationwide.
Yeah. I mean, where to begin? I think, I not only grew up in Fremont, but I went to Cal. And, I think that really imprinted on me the sense that, California in many ways is at the leading edge of the country we're trying to be. And, from going to, as an undergraduate at Berkeley, I wrote a little blog post about this for the ACLU many years ago. We threw together people from all over this state who had such a wide range of life experience from every socioeconomic class and race and ethnicity and interests. And there's this real sense of future orientation, I think, that I didn't really, it's just the air that I breathe or the water I'm swimming in until I finally leave the Bay Area to go to Yale Law School, where I encountered, an elite institution. Not that UC Berkeley is not an elite institution, but is kind of a very different
a different eliteness, right?
Yeah.
Yes.
Yeah. And, I think that the promise of California as, I think we still have kind of like a Wild West kind of vibe going where people come from all over the world to this place, to the Bay Area, to innovate. So many immigrants, right, who are doing the most incredible things in science and technology, as well as every field of scholarly endeavor at the universities here that we have here in the Bay Area. And, in some ways, it's not all a rosy picture. Fremont, as you all probably know, since I assume you all live in the Bay Area, has a very large Asian American population. Last time I checked, my high school, Mission San Jose High School, is about 85% Asian American now. It's, pretty big, 9th through 12th grade school, I think still probably around 1,600 students, if I'm not mistaken. When I was there, and I know this because I was on the student paper and did a little investigative journalism on the diversity of the student body and the faculty in my high school. I think it was around 90% white.
Wow.
And in the course of when you grow up as a kid in an environment at the leading edge of that rapid demographic change, there will be instances of bullying that is, of a racial nature, let's say. And so, I experienced that kind of, racist taunts as a kid. And then to go to Berkeley and be in coalition with other students, in a multiracial coalition, learning about ethnic studies, learning about the history of our country, and things I never knew. Japanese American internment, the real history of our country. That's all something I really credit to being in California, and to just being like I said, at the leading edge of this American, enterprise.
Yeah, thank you for showing how California leads the way and what it means for you. I love that. Okay, we've got a bunch of questions.
Okay,
now
let's go.
From our audience, so I'm going to just kick through them. This one is that the ACLU has, and it says infamously, championed unpopular, back when they were unpopular, individuals, like people seeking to exercise their freedom of speech to be, say, a Nazi. Given the strange times that we are in, are those cases deprioritized or dropped or no longer needed? Then how does the ACLU balance sterile principle with the need not to let principle be weaponized by bad actors?
I would say in times like this, it is all the more reason to stand up for principle. Particularly when it comes to the First Amendment. I mentioned our case last term in the Supreme Court where we represented the NRA. Hugely controversial. A lot of progressives who are supporters of the ACL reviled us for deciding to do that. And I said at the time, when the controversy was hot, if you let Maria Vullo, the New York State financial regulator, do to the NRA, what they claim she did in their complaint. How are you going to feel when Donald Trump is president and can do the same to the ACLU or Planned Parenthood or LDF or fill in the blank of your favorite progressive organization or liberal organization? I think it is all the more important for us to make sure, again, that we are standing up for principle and that we reach across ideological differences, because that makes us stronger when we really have to, when it really counts.
And I'll just editorialize. I don't think you'll take a position on this, given that you are a nonpartisan organization. But the standing for principle is a real contrast to what we're seeing now from our federal government. And so I offer for all of us the value of actually being able to look ourselves in the mirror and operate the same way in all times. Okay. Speaking of principle, next question is, assume California's Proposition 50 passes on November 4th. Should we expect a legal challenge? And if so, what would you think the outcome would be and when? So maybe we'll say a little bit about Proposition 50, which is, well, you go ahead.
Yeah, so as you said, standing on principle, the ACLU believes that gerrymandering is anathema to one of our fundamental guarantees, that every voter's right should count equally. Every voter's vote should count equally. And we believe that the voters should choose the representatives, not the other way around. And the other way around is what happens when you see gerrymandering, whether it's partisan gerrymandering or racial gerrymandering. Having said that, we're challenging some of the partisan gerrymandering that is happening now, mid-decade redistricting. And, I'll just say this. I think there's a difference between states like Texas saying they're doing partisan gerrymandering in a way that is calculated to dilute minorities' voting power, and states like California that are trying to counter that effort. And so, why don't we leave it at that?
Okay, I'm going to hold on to this, the difference there, but okay. Next question is, once a judgment is made in favor of civil rights and individual liberties, it seems that without the cooperation of the other branches of government, it's kind of toothless. Are there reasons to be hopeful that the judicial branch alone can save democracy?
The judicial branch is not going to single-handedly save democracy. I hope I'm not breaking news to you on that. Look, I'm a civil rights lawyer. I've been focused on litigation for my whole career. And yet I know that litigation alone is never a complete answer. Litigation most often is a rapid response effort. There are people who criticized us, for example, for bringing the cases that challenge state laws that ban gender-affirming care for transgender youth. This was the Scarametti case that we lost in the Supreme Court last term. And so there was a lot of, Monday morning quarterbacking about that. And I try to remind people, we don't bring cases in the Supreme Court.
Right.
We bring cases in this instance because 26 states passed state laws that immediately took away essential health care for teenagers. Right? And for poor teenagers who can't afford to travel to another state to get this essential health care, there are drastic consequences. There are drastic consequences for the teenagers who could afford to go to other states to get this health care. And so we challenged those laws because they violated our clients' rights. And if you don't go into court to challenge illegal state laws, federal laws, executive or legislative actions, and stand up for civil rights and liberties, then what the executive branch officials do is the law. Let me say that again in a more succinct way. If you don't challenge what Donald Trump does as president in court, then what Donald Trump does as president is the law.
Which is
right?
not our system of laws, just to be
right.
yes.
In other words, if you don't want an executive order to be the prevailing law, you need to challenge it. So litigation is essential, but it's never enough because we have to look. Many of the problems that Donald Trump is causing in terms of civil rights and civil liberties were bipartisan products, right?
Guaranteed.
I graduated from law school in 1995. In 1996, Congress passed the Illegal Immigration Reform and Immigrant Responsibility Act, one of several draconian laws Congress enacted that year that Bill Clinton signed into law. And that immigration statute instituted for the first time mandatory immigration detention. What does mandatory mean? It means people are locked up in civil detention by the federal government without any hearing, no hearing on whether you're flight risk or you're a danger to the community. We're going to lock you up because Congress has put you in a box that means we can lock you up without a hearing. We immediately challenged that law, and we've been fighting ever since. Since 1996, the ACLU has been fighting to challenge those mandatory detention laws. And so Donald Trump, I'll give you another example. He's using that now, of course. And in fact, Congress expanded mandatory detention, which Bill Clinton first signed into law with the Laken-Riley Act, which we also are challenging now. Another example, the Muslim ban. Remember the Muslim ban from the first Trump term. Donald Trump used a statute, Section 212F of the Immigration and Nationality Act, that every president has used to suspend the entry of non-citizens on the president's determination that it's needed for the national interest. And after Trump did the Muslim ban, and the Supreme Court ultimately approved his third try after he watered it down twice, when President Biden took office, we tried to get Congress to amend that law without success. Congress did not amend that law. And so a lot of these problems truly are, our work truly is nonpartisan in that we are challenging these sort of, when I argued the Muslim ban case in the Fourth Circuit, I called it a loaded gun that is sitting around in the federal code waiting for a president like Donald Trump to pick it up and use it in a way that almost everyone agrees is terrible. But what about all the times that President Obama used that law, or the times that, coming out of immigration, I have a particular view of this, that this truly is nonpartisan work. And so I have now forgotten the question, but.
I think we got there.
We got it.
But we have 17 more, so I'm going to
I'll go faster. We'll do lightning round.
Okay, so this one is, I'm reading. Okay. Thank you so much for the work you do. I'm also from Fremont. I am not, but the questioner. As someone from an immigrant community, I found that people around me have discouraged getting too involved in political dissent and are hesitant to take action or to discuss what is happening. What is the right course of action to take when people around you are vulnerable?
That's a really good question. We had this conversation recently at work. We had a meeting where we were talking about, trying to mobilize various kinds of communities to join No King's protest or other kinds of protest, or to, sign petitions, that kind of thing. And, the reality is that so many of people in this country who are deeply affected by decisions that government is making are busy trying to put food on the table, working extremely hard, and, just trying to live their lives, like I said. And, I think it's interesting, as an Asian American, I do have a relative who's a Trump supporter, and, it's funny how people, will be galvanized when something hits close to home. And I think the important thing is to try to convey a sense that we're all in this together, and that, whether you should worry about something that the president does because he could turn the eye of Sauron on you next, or because you believe in principles, or because someone you love might be affected, can we help each other to find that empathy?
Right.
The empathy, the antidote to what the Trump administration is doing is, part of the antidote is litigation. Part of the antidote is legislative advocacy. But the main antidote is empathy.
Right.
How do we help each other find it?
Right.
Yeah.
I'm going to jump in on that question too. To say it's always the right time to do what's right. So when people around you are vulnerable, it's right, and it's righteous to stand up for them, because you would want them to stand up for you. Full stop. So It's hard. It's hard for all of us, and we got to do it. So on that. Next one is, you spoke about equality. It seems that there are different ideas of what equal protection of the law means. When and how do you think it is appropriate to consider race as part of a remedy?
So when racism has caused a problem, then it is common sense that you need to use or consider race in formulating a remedy for that. That's the fundamental sort of issue in the Calais case that we have in the Supreme Court this term. And so, we could talk about this for an hour, but I won't, because we have 7 minutes.
Yes.
But let me put it this way. So much of the conservative writings of the Supreme Court, not just this current Supreme Court, but for, many decades now, has this blinkered view of American society and tries to pretend that racism doesn't exist and therefore that race does not exist. I'll give you a quick example of how people take this to an extreme. For many years, I had several cases in Arizona challenging racial profiling against Latinos by the Maricopa County Sheriff's Office when Sheriff Joe Arpaio was in office. And I was in a deposition with co-counsel, and we were deposing a commander in the sheriff's office. And at some point, he just said, look, we don't do racial profiling because we don't know what race people are. I mean, I don't know what race people are. How am I supposed to tell if I'm on patrol what race someone is? It just doesn't even occur to me. And my co-counsel, I was second chairing this particular deposition. A co-counsel who's white. He is a police practices lawyer. He is former military and looks like former military. He looks like a cop. He's not a cop. He is a police practices lawyer. But he starts getting agitated and he says, "What are you talking about? Like, what race am I?" He goes, "I got no clue." And then he turns to me. I'm sitting here. He's like, "Well, what race is she?" He says, "I have no idea." And but that nonsense in a serious way is a thread in so much of the Supreme Court's recent jurisprudence on equal protection. As someone who, started delving into voting rights law, when I became director of the Center for Democracy at the ACLU in 2017, it's like upside down world, right? I mean, so when you're doing redistricting, you're a legislator, like one of the traditional redistricting principles is communities of interest. So you take into account like, Silicon Valley, there are all these people in the tech industry, that's a community of interest. Like every community of interest, except if it's based on race, can be considered. But there's just these decisions by these courts are just divorced from the reality, right? That race is meaningful in this country because of racism, because of a history of exclusion, and people and communities' reaction to that and triumphing over that. Anyway, I could go on forever about this, but yeah, I think the court's jurisprudence is divorced from reality of American life. And for sure, when you see a violation of the Equal Protection Clause or anti-discrimination laws because of race, it makes sense to consider race in trying to address and come up with a remedy for that discrimination.
Okay, I'm going to race us through a set of questions. This one is a two-part question, and then I'm going to do another one.
Okay.
This one is, are any of the Bay Area, big tech, Silicon Valley oligarchs, that's in the question, openly or otherwise supporting the ACLU? And has the ACLU yet been the open target of direct threats from President Trump, not specific to cases, but as a group?
So we have many supporters who
are oligarchs.
Are oligarchs? No, we have many supporters in Silicon Valley and in the tech industry. We're very grateful to them for their support.
And the direct target?
The direct target. I'm knocking on my head.
Not yet.
So far, no. There was a letter that a couple members of Congress sent to about 200 nonprofit organizations, mostly civil rights organizations, most of them probably dealing with immigration issues in some way, and we were one of those 200 or so organizations that was listed in this inquiry from a couple members of Congress, but no.
in good company. All right. So in our last few minutes, we'll have our last question, which is for both of us.
Sure.
I'm going to let you.
No, you should go first.
Okay. Well, you don't know what the question is yet, but the question is: you both seem optimistic that we will emerge from this nightmare, and why? You want to go?
Yeah, I think I already answered it. I've been a civil rights lawyer for most of my life now, and I truly believe that the work is to make the promises of our Constitution, the aspirations of our Constitution, a lived reality for as many people as possible. And I'm not sure that work is ever done.
Right.
It's just the work. And you do it, and then you pass it on to those who come after you.
That's right. That's right. And that's either optimism or pessimism or just realism. But in that, I think if you're a civil rights lawyer, you have to be optimistic. You have to think that there's a path forward. And as you have said, the people who came before us lived through very, very challenging times. And our democracy is and has been fragile. So what we do is we work to shore it up, and we build a community who will do it together. And I have confidence that we are equal to this task. So thank you all for coming tonight.
Thank you. Thanks, Catherine. Thank you all.
Yeah.